Folks, we've talked about 404A and the opening of the door, the offering of a pertinent character trait to argue that the accused or the victim acted in conformity with that pertinent character trait. Well, what do I do when I have character evidence and I'm the state, right? We got character evidence, and it's good character evidence. I look at it and I go, man, you know, this character evidence makes me think that if the jury knew it, I've got a better chance of convicting the defendant. Well, the operation of 404A tells me that I can't admit it unless the defense opens the door, right? That seems fair. But sometimes this character evidence doesn't just show a propensity to do something, but it establishes a particular modus operandi, motive, prevents an argument that there was an absence of mistake or a lack of knowledge, helps you to prove intent. There are non-character ways in which you can use what is otherwise character evidence. The federal rules of evidence allow for a method for the state to admit this evidence for a non-character theory of relevancy. Now, I highlight that, I underline it, I put it in quotation marks. You've got to have a non-character theory of relevancy before I can offer character evidence as a state. And this non-character theory of relevancy is normally tied to that list of exclusions that are found in Federal Rule of Evidence 404B. And I'll just read them off to you here. Motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or absence. That's a non-exhaustive list, by the way, ladies and gentlemen. It's a suggestion from the rules, but it's not a requirement. If I can show the court how the piece of character evidence that I wish to offer falls into one of these categories and is not a general character trait, I can admit it under 404B. I've got to give notice if the other side is asked through discovery whether or not I intend to use it. But I can do it as long as I do it in the proper fashion. And I can do it proving specific instances of conduct during my case in chief. And if the other side is concerned that the jury is going to inappropriately use this evidence as a character trait for propensity under 404A, looking back on our earlier discussions about the role of the judge, what do we ask the judge to do? Your Honor, we request a limiting instruction under Federal Rule of Evidence 105. You have the ability to instruct the jury that they should only consider this character evidence for the limited purpose of a non-character theory of relevancy. Furthermore, we would ask that you affirmatively instruct them not to consider it from a propensity argument perspective. 105 ensures that if I fall into the right 404B category, I should be able to admit this evidence. So how do I do it? I first ask, is the evidence being offered to show conformity therewith? Is this character trait being offered to say, hey, he did it this way in the past, therefore he did it this way this time? That's a straight-up character evidence argument for propensity, and I've got to be under 404A before I can do it, and I cannot do it unless the door has been opened by the defense counsel. But if the door has not been opened by the defense counsel, I say, is it offered as an exclusion under 404B? And I have to define for the judge the way in which the evidence that I wish to offer this time connects to logically the case at issue in the trial today. I've got to make that logical connection. So how do I do that? I look at the issue from the previous conduct, because 404B is other crimes, wrongs, or acts. And I look to see if they're inextricably intertwined with the current event, which makes it easy. But oftentimes they're not. And if they're not inextricably intertwined, I've got to show similarities. Let's say it's modus operandi. They commit the crime a certain way every time. Many of you have seen the movie Home Alone, haven't you, right? We've seen Home Alone. And in Home Alone, you've got the wet bandits. And what do the wet bandits do? The wet bandits plug every drain in the house, and then they turn the water on as they leave, arguably to destroy the evidence of their passing. Also is somewhat of a prank, right? And so the wet bandits always fill the house with water. They plug up the drains, they turn on the water overflows, the house is a mess. They do it every single time they rip off a home. Let's say we catch the wet bandits. I remember Joe Pesci. I don't remember the other actor in that movie. We catch them, and we send them off to prison. And then they get out on parole. And lo and behold, people start burglaring homes again. And they start using the same MO. They plug the sinks. They fill it with water. Water goes everywhere. We catch Pesci. We bring him in. We charge him with the crime because we find a fingerprint somewhere. He says, oh, no, I didn't do it. Could we offer evidence of all the times he did it before on a non-character theory of relevancy because it's the same MO as whoever's doing it this time? We could never offer it under a 404A theory to say, hey, this guy was a wet bandit before, so he's a wet bandit this time. But we could offer it under a non-character theory of relevancy, saying this individual took this set of steps to obliterate evidence in the past. The steps that were taken at the current case are remarkably similar in nature to the steps that were taken by this individual previously. We're offering them to show that he had the same modus operandi, the same way of doing the crime as the other person. And therefore, it is more likely that he committed these offenses as well. It's a 404B non-character theory of relevancy. And the devil is in the details of your ability to properly tie the prior crimes, wrong, or bad act to the current charged misconduct. Now, what's interesting about this is that often the source of our other crimes, wrong, or act in a criminal proceeding is what? A prior conviction, right? The prior conviction of the defendant. The rules may very well bar me from admitting the prior conviction of the defendant. I can never get it in if he doesn't testify under Federal Rule of Evidence 609 theory, because 609 is for impeachment and it only happens when the accused takes a stand. But the underlying conduct that formed the basis for the conviction can fall into the 404B category. And the closer that I can connect that underlying conduct to the current charged misconduct, the more likely I can offer evidence of that other crime's wrong or act. And what's really cool is that the judge can parse it out. So we'll tell the jury about the earlier misconduct, but we won't tell the jury that he was convicted for it, because that would be unfairly prejudicial. Of course, as a defense attorney, I would argue, well, Your Honor, it's even more prejudicial to tell the jury that he's committed misconduct in the past and not let them know that he's been punished for it, because they're going to think that he's gotten off in the past. That's what happens when you have criminals for clients. It's one of those things that you have to deal with. So, we've looked at this connection between 404B and 404A. You should focus on how well you can identify how the previous crimes, wrong, or bad act falls into one of those categories of 404B.